can then go ahead and start the live streaming.
The Supreme Court is now in session. Chief Justice F. Philip Carbolito presiding.
Will the court clerk please call the case?
This is Supreme Court case number CVA21-004. Nadia Ngirangesil, individually and administrator of the estate of J. Wasasang, deceased, plaintiff appellant, versus Kwang H. Kim, Pyun H. Kim, John Doe Insurance Carrier number 1 to 5, and Does 1 to 10, inclusive, defendant appellee. Appearing for the plaintiff appellant is attorney William Garvis. Appearing for the defendant appellee is attorney R. Marcel Johnson. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Garvis reserves 7 minutes.
Thank you, Madam Clerk. Good morning, counsels. And Mr. Garvis, you may begin.
Good morning, Chief Justice Carbolito, and may it please the court. Appellants believe this case is an easy one for the court to resolve. We need to look at Gibbs, of course, and Gibbs is a two-prong analysis. And on the first prong, appellants win and win rather easily because the defendants in this action, the appellees, did not meet their burden. Actually, we could win on either prong, but the first prong is the easiest and most straightforward. Basically, the first prong is this, as set out in Gibbs, is that it's a question of whether the exclusivity provisions of the workers' comp statute apply. And Gibbs was very clear, and actually the courts around the country are very clear, that if the tortfeasor and the injured person are not in the same employ, then the exclusivity provisions do not apply. And that makes sense because you can't, you should be able to sue somebody if they're not your co-employee, if they do something to harm you. So that's very straight. It seems very straightforward in many cases, but where there is some overlap between the parties and their employment, it gets a little more difficult, but we have a rule that helps out, and Gibbs set forth that rule. And that rule is that the exclusivity provisions of the workers' compensation statute is limited to acts and omissions the tortfeasor commits in the scope and course of his or her employment. Now, the phrase scope or course of employment is very important because that is contractual. And that can vary. That is contractual between the employee and the business, the employee and the employer. So that can vary very much between people, their jobs, what they've contracted for, the days they work, et.cetera. And so because it's contractual and because a party that invokes a workers' compensation statute, the provisions of the act, has the burden of proving that, or at least producing evidence that of the scope and employment. Now we go to Gibbs, and if we go to paragraph 18, it's where it's discussed and discussed very, very clearly. And they say that the very first sentence, if an officer or director of a corporation is specifically charged with ensuring a safe workplace. And then we go to the very next sentence. Therefore, because the Holmeses were officers of Western and were specifically charged with maintaining, and that specifically charged language is there because Scope of employment is a contractual concept. It exists by virtue of contract and within the privity of contract.
So looking at this case, why do you say that, is it your theory that as officers of the corporation, the Kims were not charged with ensuring a safe workplace?
Our contention at this point, sir, is that the defendants had, because they asserted the affirmative defense of the workers' compensation exclusivity provision, they had the burden to come forward with that evidence, and they did not come forward with that evidence.
But wasn't there evidence that the property was utilized as for corporate purposes?
Absolutely.
And that they were officers and directors of the corporation?
Absolutely.
So when you look at 22 GCA 9135, that says nothing contained in 9134 creates a cause of action by an injured employee against an officer, agent, or director of the employer. And then the exclusive remedy, of course, as you point out, it goes on, it is caused by the negligence of any person in the same employee. So here you have the officers and directors of the corporation. And your argument is, well, they're not in the same employee, or your argument is that your argument is that the Kims have to come forward to show that they were in the same employee. But why wasn't the fact that he was on the property working, explaining to the decedent in this case, what the, how to repair, maintain the equipment was there, located on this property. It appears he was acting in the scope of his duties as an employee. And so why aren't the duties of the officer intertwined with those duties?
So I think you raised two separate points. The first point is the notion of whether an employee can ever sue an officer, and outside of, in common law. And the answer is yes. I mean, if your employer runs into you when you're both on vacation with his car, that's obviously an instance where the workers' comp exclusivity provisions wouldn't apply, because neither of you, point of fact, were acting in the scope, of course, of your employment. So you take that concept and you bring it to the facts of this case, as you suggest. And I think you have to look at the pleadings to decide the scope of what. First of all, that would apply only to Mr. Kim, not Mrs. Kim. What you're describing so far as the officer training or working with the employee. But
how do you reconcile that with the paragraph 12 of the first amended complaint, where it specifically says that Mr. and Mrs. Kim were acting in the scope of their employment at all times mentioned in the complaint?
Well, they may have been acting within the scope of their employment at all times mentioned in the complaint, but that I don't think necessarily means that, for instance, when it comes to safety, that they were acting within the scope and course of their employment.
Well, that's not what the first amended complaint says, paragraph 12, but just setting that aside. I mean, I'm having a little difficulty distinguishing the facts of this case from Gibbs. And didn't Gibbs say that officers of the corporation in which the corporation is in possession and control of the premises are in the same employ and acting in the scope of their duties and responsibilities. And so how do the facts of this case differ from Gibbs in that respect?
Well, sir, I'm hesitant to argue with the author of Gibbs on this point, but we do not believe we are certain that Gibbs does not say that. And the reason is this: there are two prongs of Gibbs, and the most charitable reading of Gibbs for the appellate, the most charitable reading, gives a presumption or a bright line rule, but only so far as the second prong of Gibbs. The second prong is dual persona. So if the plaintiff doesn't survive the first prong of a co-employee thing, working in the same employ, he can try to assert the dual persona doctrine. And it's at the dual, if you look closely at the language of Gibbs, the only time that presumption, irrebuttable presumption, can arguably apply is at the dual persona. And the reason is this: the first prong is decided by the scope and course of employment. That's contractual. The second prong is decided by duties. Now, duties is more of a legally imposed obligation. They're not the same. Scope of employment and duties are not the same. Scope of employment is the concept that exists between employer and employee, and it's defined within that tight confine, the privity of contract. Whereas the identical duties or intertwined duties, it's that word duties. Now, again, this is the most charitable reading for the appellant.
But didn't Gibbs cite cases, case law that indicate that a corporate officer who is in possession and control of the premises, at least as to this question, have the same duty to keep the premises safe as that of a landowner?
Only so far as in the dual persona analysis portion of Gibbs is the only time the Gibbs court speaks of that. And if you look at the first prong, which is the same employ analysis, it does not, and it actually is very tight on the words it used in describing that there must be, and we can go back to it. If an officer or director of the corporation is specifically charged with ensuring a safe workplace, that's the first sentence. Second sentence, therefore, because the Holmeses were officers of Western and not just, that's the end of it, but and were specifically charged with maintaining a safe workplace.
But what isn't that duty for maintaining that workplace arise from the possession and control of the premises that the corporate officer has? So if a corporate officer has possession and control, he has a duty to keep the premises safe. And that duty is identical to that of a landowner, and the duties merge and are indistinguishable, at least his duties as a personal landowner.
So I think a strong argument can be made for that so far as the dual persona doctrine is considered. Because when you go to Gibbs and when they start talking about the dual persona doctrine, that language of being an officer and being specifically charged disappears. And it goes to this irrebuttable presumption. Very strong argument can be made for that. But there's a difference between the two. And the reason for the difference, and I almost can't stress this enough, is that the analysis is different. The analysis for same employ, okay, is scope of employment. And that is contractual. whereas the analysis for the dual persona doctrine is duties, intertwined duties. And duties are imposed by law, as it's said there. And I'm going by a very strict reading of Gibbs.
So your position is that there has to be a specific agreement to maintain the premises by the corporate officer?
Well, there has to be, you could describe it as a specific agreement, or you could conceivably have an employee who is, or the officer who is then charged by the corporation and can be charged by the corporation to do this under his contract with the corporation. So if the corporation can tell the officer to do anything, then sure, absolutely. If the officer is just there to sing and dance and there's a written contract to that, then no, they can't charge him with that.
There wasn't a written contract between Mr. Kim and the corporation here, was there?
No, sir, absolutely not. But there
How is that different in Gibbs? I mean, the Holmeses, there was a written lease in between the Holmes and Western Pacific, but I don't recall anything in there that there was any type of contract that specified what Mr. Holmes's duties were with Western Pacific.
Well, I agree with you that there is no language in Holmes that says that they were specifically charged. Now, maybe that was assumed in the record and not, or recognized in the record and not spelled out in the decision. But what we know is the decision itself in paragraph 18. I mean, that second sentence, the officers of Western and were specifically charged. And given that the first sentence is saying the same thing, it's hard to say that that's not what that means, especially when you can reconcile the fact that you have this other language that Justice Torres was focusing on, the presumption, the irrebuttable presumption. But that language only appears within the dual persona doctrine analysis. And I know I'm being repetitive, but there's a reason that they're different. One is a question of contract, the first prong. The second is a question of duties, which are imposed by law. So there is a rational basis for having two different sets of rules. Otherwise, it would always be the case in with landowner. So I am, for instance, if an employee in his off hours runs on the property and the employer shoots him, thinking he's a pig or something, there's certainly liability there, because neither one was that probably acting within the scope, of course, of his employer.
Well, I mean, and that's what Gibbs said in terms of and the cases that it cites to, and if there is an independent, separate legal theory of liability, separate and apart from the his or her position as a corporate officer in the same employee as the injured defendant, then Gibbs doesn't stand in the way that the dual persona doctrine may apply in that case, or does it?
I do, but Your Honors, I am going I think I'm being true to the language of Gibbs, and in making this argument.
I understand that there is a language in there that provides the argument that you are advancing, but the later part of the opinion that also cites two cases that expands on that, in which there are presumptions
But sir,
of the corporate officer being presumed to have
Yes.
duty to keep the premises in a safe condition, where the corporate officer is also in possession and control. And at least for the facts of this case and the presumed duty of a corporate officer who's also a landowner in which the injury occurs, Gibbs seems to say that in that particular case, that the duties are incidental to employment, and they are one and the same.
Well, I think what I would emphasize is that there are two separate tests. If otherwise, we'd have one test for landowner, but there are two separate tests that are run through not only by Gibbs with landowners, but other cases with landowners. Given that they're two separate tests, it's not surprising that there'd be two separate standards in applying this test. Otherwise, they'd quite literally be the same, ipso facto would be the same test. So, and that's what I think we have to focus on. What is the test for this joint employment, this, forgive me, this dual employment concept, which is the first prong of Gibbs? And what is the test for the dual persona analysis, which is the second prong of Gibbs? They are different standards. That should not surprise us. One requires, the second one, you can make the argument. I'll concede it. You can make it a strong argument that we cannot survive under the dual persona because the duties of a landlord are the same as the duties of an officer of corporation. I can argue against that, but a strong argument can be made to that. That's the second prong. The first prong, though, is not duties. It is scope of employment, and that arises contractually and not by operation of law outside of the parties. And that is critical. And it's two different standards, applying two different tests. One of the tests makes it presumed. That's the second one, the dual persona doctrine. But the first one, because it's contractual, because it's scope of employment, somebody has to come forward and talk about, I had a contractual obligation to do this. I was charged to do this some way, somewhere, whether implicitly, as most things are done between employers and employees, they're implicit. There's not a written.
I thought that the legislature, in adopting the workers' compensation scheme and providing for certainty, finality, without fault, and not advancing, promoting direct civil suits when injuries occur on the work site, and the instances where this is brought in a civil action with civil jury trials and standards applied that may contribute to delay, uncertainty, that in that particular instance, the court, I'm sorry, the statutory scheme promotes this uniformity. But you're suggesting that in each particular case, that in order to determine in the scope of employment, every single case, there must be a showing that the employer had a specific written duty specified that he or she has this obligation that they are being held to defend on now. Is that your argument?
Well, at the end, it wasn't. I am not requiring a written contract. It's just that an employee, an officer, can be charged with something, have an obligation to the corporation not to society, which is what a duty would impose. Implicitly, orally, explicitly, orally, implicit through actions, implicit through course of conduct. There's all sorts of ways it can come about, and it's a pretty easy burden to meet in most instances. No, there's no question about that, but they have to come forward with the evidence. Because if you come forward with that evidence, how is the plaintiff going to rebut it? Say, oh no, you've been, doing this for 20 years, but this time, no written contract. No, that's not going to work. The person's been doing it for 20 years, has kept their job as an officer or director of the corporation, perhaps been paid. It's a very hard thing for a plaintiff to overcome. So I don't think it is this hurdle that you're putting on defendants, or this burden you're putting on defendants. It's a huge burden on the plaintiff because it's so difficult to overcome with just a scintilla of evidence. It doesn't have to be a written contract. It just has to be, well, we do this. I've done it. So I don't think the legislature is against this. We often have movement between workers' comp and Superior Court. I mean, if an employer denies that an employee, somebody who was working within the scope of his employment, is working outside the scope of his employment, so you don't get workers' comp, well, then the employee only has a Superior Court. So there is movement between the two. And the rules that are set are pretty strong. I don't think adhering to the literal language and to the very specific language it gives upsets at all the balance, because it is so difficult.
Why would it be a bad policy decision to say that if you're a corporate officer in possession and control of the premises, you're presumed to have a duty to maintain a safe work site, and any failure or alleged failure to exercise that duty is within the scope and incidental to their employment?
Well, I think you have to be careful how you say it. I agree with you that you could say, based upon the second prong, a strong argument can be made that they have the duty, a legal duty. Now, Justice Torres, you did say at the end that, well, this is within the scope of your employment. For the sake of Gibbs, those should be two different things. So I take your question as this. Why would it be bad policy to assume that every officer of a corporation, as part of the scope and course of his employment, is making the premises safe? It's not realistic. That's not the scope of employment, within the scope of employment of every officer. So many people are made officers of corporations, nothing to do with the corporation.
Yeah, but I think that it's not simply being an officer. It's an officer who's in possession and control of the premises, which I think distinguishes someone who's just serving strictly as an officer in name only and is not in possession and control of the premises.
And let's just look at the facts of this case. I mean, how do you explain it as far as Mr. Kim, and just following up on Justice Torres's inquiry? I mean, Mr. Kim was directly on site training Mr. Ngirangesil, and you're saying that even under the facts of these cases, of this case, that Mr. Kim was not acting in the scope of employment and didn't have a duty to have a safe environment?
Hard cases can make bad law. So let me give you a hypothetical that would make good law and support my interpretation of Gibbs. Let's say that Mr. Kim pulled out a gun and shot him. Well, pulling out of the gun and shooting is outside the scope of his employment. Now, so he would arguably win the dual capacity argument. The defendants would arguably win that because he had a duty not to. He had a legal duty not to. He had a legal duty to keep that place safe. But that was outside the scope of his employment. And under those circumstances, the plaintiff should be allowed to sue. And I think we would all agree to that it shouldn't be a workers' comp case. Or even if we didn't all agree, we can certainly understand why some people would agree that a lawsuit. So sure, you can come up with hypotheticals.
But why would that not fit within the within this judicially created mechanism that allows a plaintiff to sue for an injury and hold him liable as a third party or outside of the scope of the work-related injury?
Well, Justice Torres, I'm not so sure that Guam's workers' compensation law takes intentional torts outside of workers' comp. I don't think that's ever been decided. And I know that different jurisdictions are different on that point. So I would go back to, sure, we can come up with hypotheticals on either side. And I probably should have come up with them.
Mr. Gavris, but are you arguing that having the land in that condition was an intentional tort?
No, I'm not. I'm just, what I'm arguing is that the scope of employment requirement of Gibbs is one that should be taken seriously for its first prong. I mean, it's very explicit on that. There's nothing more explicit in Gibbs. I think Justice Torres would make the argument, and perhaps correctly. It's also equally explicit that under the dual persona doctrine, that it's not scope of employment, it's duty, and it's presumed irrebuttable. And I can agree with that. Well, I can understand the argument. I can argue against it. I can understand that argument. It's a powerful argument. But it's a separate standard. It's a separate prong than the first prong, which is scope of employment. And thus, because scope of employment is a contractual concept, someone's got to come forward with that. It's not a legal concept. It's a contractual concept. What was this person charged with? Are they inside or outside the scope of their employment? And I agree. This case on its facts could be an example of something where the law does not quite work as effectively with the policy that we want. But that's the nature of laws and courts' decisions. Sometimes they work better with some facts and give us a more just result. And sometimes they work less well with other facts. But the important thing, at least as lawyers, is that we know the law and we follow it and we advocate for it. And I think Gibbs is very explicit on that first prong, what the requirements are of that first prong.
I think your time has run in terms of your complete 30 minutes, if I'm not mistaken, but we'll allow you some rebuttal time.
Okay.
At this time, I'll recognize Mr. Johnson.
May it please the court. My name is Marcel Johnson, and I represent the defendant appellees Kwang H. Kim and Pyong H. Kim. Before I go into my roadmap, there's one point that I would like to piggyback on Mr. Gabris' argument with, and that goes with respect to whether or not there's an implicit duty for officers of a corporation to provide for the safety of their employees. And I think there it's important to look at the Gibbs decision, but not only the Gibbs decision in the Supreme Court, but also the decision that they affirmed at the Superior Court. I went back to look at that decision to see what the actual finding of fact was by the Superior Court. And there, the court said in a decision in order filed on November 9th, I think it was 2004, that as officers of Western, defendants had a duty to maintain a safe working environment. That was the finding by the Superior Court in the Gibbs decision. And I don't believe there was any separate finding by the Supreme Court that there was any contractual duty that was accepted by the officers in Holmes, Mr. and Mrs. Holmes, or that there was any other proof to show that they had a duty, that they undertook a duty to the safety of the employees, other than the fact that they were officers of the corporation. Now, if we were to look at the facts in this case, they're actually a little more clear than we had in Holmes to show that there was at least some basis to say that these Mr. Kim and Mrs. Kim at least displayed acts that showed that they had a duty to, that they undertook a duty to safety to their employees. As has been said earlier, Mr. Kim was training Mr. Wasisang at the time of the injury and equipment that they were going to be using the next day. The one important factor that I would point out that hasn't been mentioned, that was brought up in Mr. Kim's declaration that was filed with our motion for summary judgment, is that when Mr. Wasisang was injured with the forklift, it was Mr. Kim and Mrs. Kim who extricated Mr. Wasisang from the forklift and did first aid on him until the EMS team arrived. So while there may not be an explicit contract here showing that they had a duty as officers of the corporation to provide for the safety of their employees and the safety of the workplace, it shows that in the situation in which the employee was injured in this matter, Mr. Kim and Mrs. Kim specifically undertook that duty and showed that they at least understood that they had that duty, as whether or not as officers of the corporation or as employees, which they both said they were under their declarations. They undertook that duty or actions that show that they understood the duty to take care of that employee who was injured.
Justice Carbolito asked the appellants about their first amended complaint that alleged that the Kims were acting within the scope of their agency employment or partnership, which was set forth in paragraph 12. But you also denied that provision of the amended complaint that said they were acting within their employment. And isn't the record kind of scant as to Mrs. Kim's job duties, other than perhaps identifying her as, you know, the president and the secretary and preparing annual corporate reports? It seemed, I mean, you say that she was there tendering and rendering first aid to the decedent in this case, but you know, she was also there as a property owner, and one would think that as a property owner, if someone is injured on your property, you would take the appropriate steps to you know, render first aid. So isn't the record somewhat scant on the evidence of her job duties and the duties to maintain the premises?
I would say to a certain extent, Your Honor, but I think the question is whether or not there is enough evidence in the record to show that she at least did have some sort of duty as an officer of the corporation, or that she undertook that duty to maintain the premises. And I think that's where it's really important to look at the dual persona doctrine here, because it's not clear. It's clear at least that those duties are the same for a person who's for the corporation that's leasing the premises and for the landowner of the premises, or the corporation that has permission to use the premises. Both the corporation and the landowner have a duty to maintain, or to at least to render aid to maintain the safety of the premises for the employees and any invitees.
Does it matter that the property was used personally by them in addition to being used as a business, a place of business? Does that make any difference?
I think it might, only to the extent that if this injury had occurred in a place where the injury wasn't, where the business wasn't involved. Say if it had happened inside the household in their living room or in their bedroom, that would be a little clearer. That would be a separate, that would be separate from the corporation. But here it's clear that he was injured on a forklift while he was being trained. To think about examples where somebody with a dual persona doctrine might not apply, I can imagine a situation in which maybe the Kims owned a dog. They kept it for their personal use. It wasn't a guard dog for the corporation. If it had gotten out of the house and bit Mr. Wasisang, then that clearly they would have a separate duty as dog owners under the leash law of Guam. That would be separate from their duties as officers of the corporation to maintain a safe workplace, and therefore they would be open to suit as a third party. Or if they had a personal car that had hit Mr. Wasisang at some point, or if they owned a separate piece of property next door that was not used for Daesan Corporation, then they would have a separate duty that was completely separate from their ownership of the property in question here. And I can see those would all be examples where the dual persona doctrine possibly apply.
What about if they own the premises as in corporate form rather than personally? Would that change the analysis? Would they have a persona independent from their status as an employee?
Just to make sure I understand your question correctly, Your Honor, do you mean if Daesan Corporation own the property itself where this was happening?
No, if the Kims had a separate corporate entity that owned the property.
Well, then I suppose it would be the separate corporate entity that would be the subject of the third-party lawsuit, then, Your Honor. So I think that's maybe not the best analogy here, given that there would also be a separate layer of ownership there. So the third-party entity would clearly be the one that's responsible. But here, since they're the officers of the corporation in question here, and they're also the owners of the property here, that's where the dual persona question really comes up.
What about Mr. Gavris's focus on the language in Gibbs, where Ngirangesil points to that language and were specifically charged with maintaining a safe workplace, was injured by the negligence in the same employee. And so his argument is that there must be, that Gibbs did not adopt a bright line rule, and that created a presumption that if the officer of the corporation in its possession and control, that they are presumed to have this duty to maintain it in a safe condition. And there must be some showing from this language that he seems to focus in Gibbs, that there must be some type of showing that Mrs. Kim, in her capacity as president, also has had a responsibility of maintaining a safe workplace by actions and prescriptions that came about from her position rather than just the title of the position.
Well, then, Your Honor, I think it would be important to look at the context of the court statement in Gibbs and to look at the cases that the court cited in making that statement. Here, the court was specifically stated that it was taking New York case law into this matter as persuasive authority. And in making that statement, it relied on numerous New York cases, including Paranello, which specifically stated that because the defendant was both the owner of the building and an officer of the corporation which employed plaintiff, we conclude that his responsibilities to provide her with a safe workplace, a safe place to work, were merged. Also, I should mention that the Superior Court case that was appealed in the Gibbs case also cited Paranello in that section in Paranello for the same proposition, that an officer of the corporation has an implicit duty to provide for a safe workplace for their employees.
But that can't apply to every officer, though, right? I mean, or you're saying that it applies to every officer.
I believe that
there are some officers who aren't in possession and control of a workplace who have, just tangential duties as an officer. There are many entities that have officers serving in that capacity. They're not involved with the day-to-day operations or with the maintenance of the premises.
that is true, Your Honor. But I think there are 3 points I think that I would raise to answer your question. First is that it's at the New York case law, at least that the court was relying on in the Gibbs decision, seems to show that it doesn't matter whether the officer was a sort of an officer in name only, or whether the officer had an active role in the running of the corporation. It seems, at least, that, especially if you look at the jury instruction that exists in New York, there's no exception that shows that the officer has to at least have some showing that they undertake some duty or some day-to-day or some control of the day-to-day operations of the corporation. And the second point that I would raise is that the annual reports that were filed in the declarations by Mrs. Kim show that this is a closely held corporation. It's not like there are a bunch of other officers here who were extraneous to the operation of the company. The third point I would raise is that, well, I guess that with respect to these officers that have nothing to do with the company, sort of how Mr. Gavris mentioned, officers that are just here to sing and dance. Clearly, these two people were not here to sing and dance. Mr. Kim was there on the date of the incident, training Mr. Wasisang on the use of the forklift. Mrs. Kim was there to help extract Mr. Wasisang from the forklift and to provide first aid at the time of the injury. And I understand that maybe she was there because this is her residence. But the fact of the matter is that this property is listed in those annual reports as both the principal place of business and the residence of both Mr. and Mrs. Kim. I think the fact that these people live on this premises and work on this premises kind of helps show that there is at least a merging of the duties of these people and the merging of the responsibilities that these people have to the property itself and to the corporation, which really underscores the whole reason why the dual persona doctrine should not apply here. I had a roadmap that I wanted to follow. I think I should focus on maybe with the time that I have left, I think I'll try to focus first on the third point that I initially intended to raise. That has to do with the factual issues that are relevant to this appeal. I think we've gone over some of those, but I think it's important to point out that that first, this case is distinguished from the Evans case that is heavily relied upon by, is distinguishable from the Evans case that is heavily relied on by the estate. The Evans case, it was clear that the court had an issue reconciling what the duties of the wife and possibly the husband were at the time, showing that there was no indication that the wife was employed by the corporation. Here, the declaration by Ms. Kim states that she was employed by the corporation. That wasn't opposed in any way by the estate at the motion for summary judgment. Here it shows that the wife had no duties to the corporation. Here it shows the wife performed no services for the corporation. The wife received no wages in any form of compensation for the corporation. Here it's at least clear that through the declarations that were filed by the Kims at the Superior Court, that they at least undertook certain duties to the corporation. They were both employees of the corporation, they were officers of the corporation. They took actions at the time of the incident to do things for the corporation. None of those facts were present in the Evans case. And those are the facts that I believe the Evans court turned on in order to show that there was no that their ownership of the property was separate from their duties for any role that they played as officers in the corporation.
I mean, isn't in the Evans case, the dissent more in line with the Gibbs case in reference to the application of the dual persona doctrine? There, the dissent argued that there must be something separate and a separate duty or some, excuse me, go ahead.
Yes, Your Honor.
And that they just, the Evans majority really just would disagree with the Gibbs application of a presumption that if the officer is also in possession and control of the premises, that the officer has this similar duty as a landowner, and that the landowner also has the same duty of keeping the premises safe. And for that reason, the Gibbs and then the dissent are saying that that is incidental to employment, within the scope of employment in the employee language of the statute. And it's because that there was no separate independent showing that it was a different duty and in which the injury arose out of, that, and so the Evans majority was just a different acceptance of what in the same employee means as announced in Gibbs.
I think I understand your question to mean, Your Honor, that the dissent would be more in line with the Gibbs decision that was issued by the Supreme Court of Law. But I think it's best to look at them both in the sense that whereas the dissent was really interested in.
Because I think if we were to follow the majority, and then Mr. Gavers's point that there must then be some showing that the Kims had a specific duty as part of their responsibility as an officer of the corporation to keep the premises in a safe condition, other than the presumption that arises from their position as an officer of the corporation in possession and control of the premises. And he, Mr. Gabbers, focuses in on that language in Gibbs that said that they are specifically charged with this duty and responsibility.
Yes, I mean, honestly, it seems odd to find a situation in which the owners of a closely held corporation that was involved in construction or construction type activity would not be charged with the safety of the workplace. Here, I'm not sure who else could have possibly been charged with the safety of the workplace if it had not been Mr. and Mrs. Kim, who both own and work on the property here.
I think the facts of the case may illustrate that point, in reference, as you pointed out, that Mr. Kim was specifically in his capacity as an employee of the corporation training Mr. Ngirangesil, and there it was pretty clear that this action was in the scope of his employment. Yes. And whereas with Mrs. Kim, there was no showing that she had any specific duty in reference to the work environment and just the work that Mr. Ngirangesil was performing as in terms of this heavy equipment operation, other than being an officer of the corporation charged with the responsibility.
Well, and I think the concern there, Your Honor, that we would have is that if it turns so easily on whether or not somebody has undertaken a specific duty of safety to the company as an officer of the corporation, whether or not they may have that duty or may have undertaken that duty at that particular time, whether Mrs. Kim was inside the house or outside the house, or whether or not there was an agreement as to when she would be responsible for the safety of the workplace, then it would really become we'd be opening sort of a Pandora's box as to whether or not anybody has any safety any responsibility to the safety of the workplace. And it would be a much better policy decision to adopt the bright line rule that New York has, that if you are an officer of a corporation, you are charged with maintaining the safety of the workplace for your employees. It's simply much clearer for everybody involved. And I think there is a section in the Evans decision where they speak to the fact that the purpose of workers' compensation is to make sure that the administration of of claims where workers are injured is done in a clearer and a shorter method to determine whether or not an employee is entitled to compensation at the time, rather than going through the length of litigation. And I think if the court were to move away from a bright line rule in this case and towards something that's a little more what Mr. Gabbers is asking the court to adopt, then we would really wind up in a situation where more litigation would result from workers' compensation claims of this like than has in the past, which I think would.
So if this court was to clarify, if it didn't already state it so, and that the Gibbs did, at least as to the facts of this case, that there was this presumption, does that mean that there is a per se rule of liability of corporate officers when just for the fact that they are officers of the corporation, that they are protected under the workers' compensation immunity provision?
I believe so. If the court were to adopt the position that was stated in the New York cases that it cited in Gibbs, then that would be the result. The opposite result, if the court were to move away from it, would be that there would not be a presumption, and that pretty much every time that somebody is injured in a place of work that is owned by a landlord who was an officer of the corporation, then it would become a factual inquiry as to whether or not that owner and landowner undertook a specific duty of safety to the corporation as an officer to the corporation, which would then become a drawn-out factual inquiry for any litigation that would result from any.
But there's not a per se rule of liability. I mean, you pointed out the dog case where if Mr. or Mrs. Kim had a dog in the house that got loose and bit Mr. Ngirangesil, that in that case, just because they are an officer of the corporation, doesn't mean that they are cloaked with workers' comp immunity under that particular factual hypothetical.
That is true. However, that's why the dual persona doctrine, I believe, exists, is where there is a situation, and the rule itself is, it does seem to stress that that duty is separate from the way the rule is stated in Gibbs is that the officer may become liable as a suit as a third party if and only if he possesses a second persona so completely independent from and unrelated to his status as employer that by established standards of law recognizes the employer as a separate legal person. I mean, all of the scenarios that we can come up with that involve, say, a dog or some other form of liability are clearly much different than the situation that the court is faced with today, where we find a person who was on a forklift on a piece of property. And it's clear that he was working at the time of the injury. He was working on a forklift, and this is a mechanical equipment company. So it's much clearer here that this was within the scope and within the work environment, as opposed to within some sort of separate duty that the landowners owed to him by virtue of a dog or by virtue of something else.
But if you look at the Evans opinion and in discussing the exclusive remedy provision of the workman's comp law, it makes note that it's to give immunity to employers and employees who are acting in the scope and course of their employment. Its purpose is to not create this artificial immunity to someone whose only connection with the corporate employer's business is to have their name on a piece of paper as an officer or director. And in that case, it would be against the policy or frustrate the policy for the legislature that reimbursement from proceeds come from the third party action. So, the idea that it should be automatically a bright line test, and anytime someone is an officer of a corporation is sufficient to provide the immunity from the exclusive remedy provision, I think it's a difficult thing for me to grasp or to accept. It seems that there has to be more than just simply you're an officer.
I could understand that, Your Honor. The only thing I could really point to really is the fact that in Gibbs, the court did rely on numerous New York cases that have all held really in the same way, and that the New York jury instructions all hold those as well, and that the New York legislatures had the opportunity over the years to make that change themselves, and they apparently didn't see any issue with it. I mean, the Guam legislature has not made that change since Gibbs, and I understand this is probably a little more nuanced, an issue that the legislature may not possibly have gotten to, but the legislature itself has not made the decision to change how the workers' compensation law should be interpreted since Gibbs was decided back in the early 2000s.
Well, I think, but don't the New York cases also focus on the conduct of the co-employee committed within the course of employment? So if the conduct is not in the course of employment, do they lay a bright line test that says course of employment automatically for every person who serves as a corporate officer?
Yeah, Your Honor, the New York's pattern jury instructions state that in addition, a worker who is injured during the course of the employment cannot maintain an action to recover damages for personal injuries against the owner of the premises where the accident occurred when the owner was also an officer of the corporation that employed that worker. The rule doesn't draw any sort of distinction as to what the responsibilities of that officer are. And the cases that they cite, it cites Lavario versus Wuoro. And in Lavario, that case follows that, workers, the plaintiff who's injured during the course of his employment cannot maintain an action to recover damages for personal injuries against the owner of the premises where the accident occurred when the owner is also an officer of the corporation that employed the worker. New York case law, which this court has followed in the Gibbs decision, is very clear. It doesn't paint any sort of particular distinction between what type of officer of the corporation it is. It simply states that the owner of the land must also be an officer of the corporation. These are, I mean, I understand this doesn't open it up to the possibility of everybody, but as I think you stated yourself, Your Honor, that the owner of a piece of property would have their own interest in making sure that the premises is safe. So it wouldn't necessarily be just the sort of a random officer of the corporation who would have no individual interest themselves in this. I think the whole point of this of the dual persona doctrine is the fact that the personal interest of the landowner merges with their duty to the corporation as an officer, showing that, you know, clearly under both of these responsibilities, they should ensure that the property itself is safe.
But in that instance, the person is acting in a capacity other than just as an officer's, in name only. I mean, you have him as an owner, you have him essentially in possession, it seems, of that property and in control of that property as the landowner.
Yes.
And so, that makes it different than some officer who has no possession, has no control, is an officer in name only, and is not the landowner. I mean, that would be a different situation. And
Yeah.
to say that officer should be entitled to immunity under a bright line test simply because they're an officer of the corporation, I don't think is what was contemplated by the exclusivity provision.
That's absolutely right, Your Honor. But if you look to the New York cases, that they also require as a prerequisite that the officer be an owner of the property itself too, though. So it's not necessarily that the
right. I mean, and I think that's what distinguishes the New York. So it's not a bright line per se that automatically an officer can escape immunity and would automatically be within the same employee.
That's true, Your Honor. The bright line that I'm referring to is a bright line that states that the officer is also the owner of the land on which the corporation is using for the place of business. Then that officer would be immune from liability. That's we're not expecting anything broader than that for the officers of the corporation.
Mr. Johnson, if we assume that there was a failure of proof as to what Mrs. Kim's role was in the corporation, this would have to go back. Would you argue it's just as to her duties or to both of them as to their responsibilities? I'm just trying to figure out how this would work if they're both landowners of the same parcel.
Yes. And again, we mentioned in the brief that we did ultimately determine that she is really the only landowner, but so assuming for the purpose of this argument that they are both the landowners, I think it would apply to, Mr. Kim would already be immune from liability given the fact that he's a coworker, and he was training Mr. Ngirangesil at the time of the injury. The question would be Mrs. Kim, and Mrs. Kim really falls under the question of the dual persona doctrine. And really what we'd ultimately have to determine on remand was whether or not what the extent of her duties as an officer of the corporation were. And I think given her actions of the date of the injury, it would be fairly easy for us to prove those facts to the court, sufficient to show that she wasn't simply an officer who was here to sing and dance. She was an officer here to actually participate in the running of the corporation and the company. I think it would be fairly simple for us to show. In conclusion, I believe that the facts developed in the Superior Court clearly show that the land was owned by the Kims. The land was both the principal place of business of the corporation and the residence of the Kims, that the Kims were both officers of the corporation, and that Mr. Wasisang was employed by the corporation and was being trained by Mr. Kim at the time of the injury. As a result, the Kims owed a duty of safety to invitees and landowners. The Kims owed a duty of safety to their employees as officers of the corporation. And Mr. Wasisang was injured in the course of his employment. His estate's sole remedy is through the workers' compensation statute, and the exclusivity rules should apply here. Thank you.
Thank you, Mr. Johnson. So how much time does Mr. Gavras have, Madam Clerk?
He used all his time, but you said you would give him additional time.
I just wanted to confirm that.
Yes, he did, and he went 1 minute over, actually.
All right. Okay, Mr. Gavras, I'll give you 3 minutes to sum up your argument.
Well, thank you, Chief Justice Carlito. I would like to use the time to give a hypothetical, which I think addresses the public policy question, also drives home my point why the scope of employment analysis, which has to be contractual, is critical. Imagine two employees working on no one's land in particular. One of the employees is putting those punji sticks all around, sharp punji sticks, and hiding them. The other employee gets hurt. Now, that first employee is acting out of the scope of his employment because they're supposed to be selling ice cream. I don't think anyone would think that the injured employee shouldn't be able to sue in common law the negligent employee. Now, the negligent employee could say, no, we also are operating today a military training ground. So that would be his burden to come forward with that. Now, take the same situation, except this employee that is putting the dangerous punchy sticks everywhere is a landowner, and they're doing it on his land, and somebody else, one of the other employees, gets hurt. Well, should that person, should that landowner, should that officer, landowner, and say he's an officer, should he have any more protection than that other employee? I don't think any of us would say he should. Now, he'd have the same ability to come forward and say, you know, we're running a military training thing, so it was within my scope of duty, scope of employment to put this stuff around. But I think it drives home the point that we wouldn't want to treat the one differently than the other just because he's an officer and just because he's a landowner. The question is scope of employment. Scope of employment can be very important because if you are running a military training camp, then the plaintiff can't meet the first prong of Gibbs. And I think that example shows why there is, in Gibbs and other cases around the country, this insistence on scope of employment being proved up, and why it's different than the second prong of Gibbs, which is dual capacity and goes to duty. So with that, I really appreciate your time. Thank you for hearing our arguments.
Thank you, Mr. Gabris, and thank you, Mr. Johnson. The court will take the case under advisement, and the court stands adjourned.
Thank you, Your Honor.
Thank you. Thank you, Counsel.